Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. Late last night, the Wayfarer parties filed a letter in opposition to Blake Lively's latest motion to compel. In that motion to compel, Blake Lively was asking for documents, witness recordings, communications relating to an independent investigation into her sexual harassment claims. The investigation started in January 2025 and was triggered by Blake first making her sexual harassment claims in her CCRD complaint in December 2024. Yes, first making those claims in December, because that's when that happened. I'm fine. Everybody's fine. The investigation is conducted by a neutral firm, and Wayfair doesn't have any of the documents, witness recordings, whatever that she's asking for, because they're not going to get that stuff until the investigation is over. But Blake had filed a motion to compel Wayfair to give them that information anyways, and in doing so released her correspondence between her attorneys and the independent firm doing the investigation. In those letters, we saw plain as day she was sending a cease and desist and trying to shut down the investigation into her sexual harassment claims. Bear in mind that part of their investigation is to find out whether or not any sexual harassment complaints were actually made. I'm going to go over some of this letter here. The motion should be denied because it seeks disclosure of materials that are not in the Wayfair entity's possession, custody, or control. Correct, this is a massive waste of time. Lively first contends that the investigation is a disingenuous charade because the Wayfair entities should have, but failed to investigate Miss Lively's concerns when she first raised them in May 2023, distorts the record. Lively fails to note that her allegations were first disclosed on December 20th, 2024, in the complaint Lively filed with the CCRD. The current investigation was promptly initiated by Wayfarer in January 2025 when they retained Rains, Feldman, and Luttrell and Adam Investigations Counsel to conduct an independent investigation into Lively's newly surfaced claims. Second, as Lively is well aware, the investigation is ongoing. Accordingly, the investigators' findings, reports, witness statements, and related materials have not been disclosed to Wayfarer. The Wayfarer entities have no documents in their possession, custody, or control that are responsive to Lively's request, and so informed Lively's counsel on May 10th. So 11 days ago, they were like, hey man, we don't have this stuff. And then they just thought, well, we'll just ask the judge to make you give it to us anyways. As this court has previously held, a party cannot be compelled to produce materials it does not possess. In fact, the Wayfarer entities presently have no knowledge as to whether such documents in fact exist. Third, Lively's contention that the materials from the ongoing investigation fall outside the protections of the attorney-client privilege and work product doctrine is baseless and contrary to well-settled law. The investigation is being conducted by outside legal counsel retained to independently evaluate Lively's recent allegations through a confidential, privileged legal process. The investigators are using their legal training and professional judgment to gather and analyze facts for the purpose of advising Wayfarer on Lively's new claims. Courts have consistently held that such investigations, when undertaken by counsel to render legal advice, are protected from disclosure by both the attorney-client privilege and attorney-work product doctrine. Lively's demand that the Wayfarer entities identify all witnesses contacted and turn over notes, recordings, and communications relating to those interviews, even while the investigation is underway, is not only invasive and unprecedented, it seeks to undermine the investigative process itself. Especially given the high-profile nature of this litigation, premature disclosure of requested materials would risk chilling witness candor, distorting the fact-gathering process, and undermining the neutrality that is fundamental to a credible inquiry. Fourth, Lively's claim that the Wayfarer entities waived privilege by placing the adequacy of the investigation at issue vis-a-vis its 13th affirmative defense misrepresents both the timing and scope of that defense. Finally, the investigators, to whom Lively has issued a subpoena, have properly objected to the subpoena on privilege and work product grounds. While the Wayfarer entities take no position here on the contents of those objections, their existence demonstrates that the discovery process regarding those materials is already proceeding through the proper channels. Should Lively wish to contest any specific privilege claims or other objections, the appropriate route is to do so via the subpoena process, not by seeking to compel the Wayfarer entities to produce materials they have not received. All right, that's all I got for now. I will be with my friend Zach Peter on his show today. That'll be at 9:15 a.m. Pacific, 12:15 p.m. Eastern. Hope to see you there, and if not, then you can just pretend that you were. See ya.